Okay, thanks for being back. I know that the discussions are, becoming more and more exciting, and so, and we are ready, to actually provide more food for your discussion with the next presentations. And we go for the next one, Nikolaus Forgo, University of Vienna, Austria, Internet Law in a Global Context. The floor is yours.
Thank you very much. Can you hear me? Is it appropriate? No, not really. Okay, so what do I need to do? It's not on.
It's not on, probably.
It is on.
It's on mute. So now.
Okay, can you hear me now? Yeah, it's better. Okay, much better. Thank you. Okay, good morning. Thank you for giving me the opportunity to speak to you for about 35 minutes. I need to make a lot of confessions. One of them is I'm probably a rather strange animal here because I'm one of the very few lawyers here. I must also confess that I feel a little bit, isolated in many of the views that you will hear in the next 35 minutes. So there will be a lot of food for debate, certainly, in what I'm going to do. But I'm very much looking forward to this. Just to introduce myself a little bit closer. So I'm back in Vienna now for about 2 years. Before that, I worked in Germany for about 15 years at the University of Hanover, which is in the northern parts of Germany, a typical German technical university. What I did there, inter alia, was that I was also Chief Information Officer of the university, and I was Data Protection Officer of that university. So I do have some kind of administrative background knowledge as well as not only academic knowledge. But what I mainly did there, and what I also do now in Vienna quite intensely, is that I was quite intensely involved in European-funded research projects. So each of those little logos here stands for about 10 to 15 million euro budget, funded by public sources. That's important to know. And many of them looking quite similar in the sense that in each of these projects you have about 5 medical partners, you have about 5 technical partners, and then you have one partner who is the killjoy in the game, so the boring one, the one ruining everything, which is the lawyer taking care of the legal and ethical aspects. And what those 5 technical and those 5 medical partners have promised when they received the funding was there is a certain disease, let's take breast cancer or Alzheimer or Parkinson or whatsoever. There is huge amounts of data out there isolated in different hospitals. We are stuck when it comes to treatment of these diseases. What is therefore needed is more interaction between those silos. Let's get the data more connected, and let's make it possible that a researcher in the institution A gets access to institution B. That's the promise. The business model of the technicians in the consortium is we make this possible. We build the infrastructure to make this possible. And the business model of the medical partners is we own the data. We don't want to do anything in this project, but we have 10,000 patient data sets here, and we are able to and willing to share them. And then the project starts. Normally, it's a 4-year project, 10 million euro. The project starts. There is a lot of, happiness at the beginning. Barbara would say it's the honeymoon phase of the project, right? So there's a honeymoon phase of the project. It takes about 2 years, right? Everybody is promising, let's do this, and the technicians start developing their code, et cetera. And then after 2 years, the medical partners suddenly come up and say, listen, we have a tiny little problem here, because when you said that you need the data, you really meant that you need the data, right? And you really want it now because, there is an ethical committee in our department, and then there is the data protection officer. And I'm not really sure that I really want to share this because I have some kind of intellectual property claim which is not covered in the consortium agreement. And let's ask the lawyers in the department. And then it's year 3. And then the technical partners start being a little bit nervous, right? Because they have promised that they will develop something groundbreaking on Parkinson or Alzheimer or breast cancer. And there's still no data. And then they all kinds of circumvention measures start, like let's take fake data, or let's take data where we of virtual patient cohorts. That's the new buzzword in the scene, right? And then or let's take data that is already published somewhere and we don't really know whether it's legal, but let's assume that it is, right? And then it's year 4, and then the project is over. Right? And that's it, right? And I've seen this, I don't know, 15 times in my career so far, right? And it's very, very similar in many of those cases. And then the nasty thing is, in year 3 and 4, my position in these projects becomes really stressful, because then it's very easy to blame the lawyer in the game, right? It's always the lawyers then not having seen this or not having made this possible, blah, 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 blah. And I'm very happy to be able to share this frustration now with you. That helps me a lot. The problem behind this is it's a lot of money that is invested in this way, and I don't see too much of Parkinson treatment coming out of this, or breast cancer treatment coming out of this so far. Although something might have changed due to the 25th of May 2018. So the 25th of May 2018 brings me to another confession, which is that I was born on the 27th of May 1968, right? So one of the standard jokes that I constantly made between 2016 and 2018 was that the GDPR was the perfect birthday present for somebody getting 50 on the 27th of May 2018, because that in reality guarantees that I will constantly have work to do without really needing to adapt to anything else, right? Because there's so much in this that it will keep me in business for the rest of my life. That's the positive part of the story. The negative part of the story is it brings me in a kind of midlife crisis, and you see this already, right? And I will talk about that midlife crisis, which has also something to do with this panic mode that started and that happened around the 25th of May 2018. And that panic mode was something that brought me very much back to 2012, when all this story started yesterday. Because what I did yesterday, I'm always late in preparing my slides, I'm sorry for this, but the bonus of this is, or the positive side of this is, I can change things. So one of the things that I changed yesterday after Moshe's most impressive presentation that I really admired and liked was I wanted to get this, right? So he showed this slide with the truck driver being the typical American job. And I wanted to get this. And when I wanted to get this slide, this was what I saw, right? So this was my day-to-day impression. If I do a stupid single search on the internet trying to find a banal, stupid screenshot, so I see these stupid, nasty, never read by anybody agreements to cookies and all kinds of other data processing taking place on these machines. This is GDPR for me. This is the outcome of GDPR. That's the only thing that changed for people like me after GDPR. You get this in all kinds of differences. A very nice.
At least they let you access it. There are some newspapers.
Which don't. Yeah, true. Well, this is something where I don't get access. This is an interesting example. That's an Austrian example. It's an Austrian newspaper, one of the traditional left liberal newspapers. So rather interesting example. You don't get access if you are using an ad blocker, right? If you use an ad blocker, you have two options. Either you pay €6 or €3 or whatever per month, or please allow us to track you using cookies. So that no access without this option. It's easy to pay €6 for their standard, but it's not that easy if you need to pay €6 every time you want to access any stupid website out there. It will not be that easy. So that's GDPR, and that's my midlife crisis, right? So the midlife crisis started somewhere to develop in 1968 when I was born, and it's at its peak at the moment, right? Thank you for sharing this. And the reason, or for listening to this, and the reason for this is in this picture. This is how the computer world looked like in the year of my birth. This is from 1968. For the younger ones in the room, this is a telephone, okay? This here is the only woman in the room, right? And it's a beautiful picture in my view, because this, this gentleman here has this kind of, a little bit depressive, a little bit melancholic view into the future, right? And the person working here, also quite nicely dressed, has all kinds of different huge parts under control here. That's a computer in 1968, right? When I was born. So, and this is a computer in 2018, when I'm 50. This is a screenshot. It's again 2 gentlemen, no woman in the picture. Again, huge machines. The difference is he's not really nicely dressed any longer, right? And the second difference is there is somebody wearing a uniform here, which is not a policeman, interestingly. That is somebody from a public service, because the only reason why this person is here is that this person here tells the audience in a YouTube video what a good idea it is to use Google Drive services and Google Cloud services. And the role of this person is to simply stare into the camera and make everybody aware of that it's really dangerous to get into Google, right? So this is everything. So no, he doesn't speak. It's not really a very attractive role. Yeah? This one here is allowed to speak. So this is a screenshot, Google 2018 Cloud Services. It looks very much the same, doesn't it, right? But there are some tiny differences. One of them is this is a privately owned company, right? It's no longer the state running the machine. And it's a US-based privately owned company, which causes all kinds of regulatory issues from a European perspective. But apart from this, not too much has changed. There was a time in between, somewhere in 1995 or so, when the web made its first huge success story, where everybody believed that that would democratize the world in the sense that everybody could do whatever he or she wanted to do. That's over. We are back where we started in 1968. And we are back in a world that at the same time is confronted with all kinds of regulatory promises. This is the claim by which the European Commission sold the GDPR in 2012. One continent, one law. It should finally be fit for the technologies we are all working with, and it should be one law, not like the US approach, one for medical and one for consumer and one for the whatever industry, but just one for everything. That was the promise. And as you probably know, and hopefully share with me, none of those promises have become true. And the reason for this might be, inter alia, that there is still a huge gap in the legal versus the technological development. And why this? Because when this first internet hype we started to talk about yesterday quite intensely, when this first internet hype started somewhere in the 90s, and when the politicians started to see this as something worth of being part of a regulatory approach, the issues were like, they very much looked like this. There was a problem of enforceability. So already in 1995, it was quite clear that the internet is a global phenomenon and that it makes a problem to try to enforce Austrian or German or Irish law when the computer is based somewhere in Australia or in wherever in the US. There were issues of provider liability. There were issues of access to justice, all the points that I mentioned here. And the answer given from European legislators on this was a huge wave of legislation, starting somewhere in between 1993 and 2002, a huge wave of legislation producing all kinds of negative responses coming from technical perspectives, such as this one here. This is a very prominent and well-known article from 1993, where it's then mentioned that 20 million new users per month were added to the amount of users given. In this article, we read this famous quotation of John Gilmore: "The net interprets censorship as damage and roots around it." Gilmore's website, by the way, looks today like this. This is a screenshot from yesterday, so he still remains a little bit in this time, I think. So The net interprets in censorship as damage and roots around it, or something like John Perry Barlow with his famous Declaration of the Independence of Cyberspace in 1996. So governments of the industrial world, you're very giants of flesh and steel. I come from cyberspace, the new home of mind, where you are not welcome, right? So this huge, pathetic approach, we don't want this regulation at that moment, and we don't need it. However, that was not heard. There was a lot of regulation ongoing then, a lot of European laws, data protection, copyright, e-commerce, databases, telecom, whatever, take whatever you want. However, none of the problems from 1995 are solved at the moment. So the situation is exactly the same at the moment. Still, we have issues of enforceability, we have problems with provider liability, access to justice, everything still the same. However, what we are seeing now, in particular after Juncker, so the current head of the Commission has come into power, is a second huge wave of internet legislation, just like in 1995 again. And GDPR is just one of the many phenomena that I could show here. However, leading to something which is again very, in my judgment at least, in a very, very disconnected format from the technological environment. The reality, just to put you one example here, the reality how GDPR looks like at the moment is that it's much more visible. People have a lot more of interest in data protection. However, we still face tremendous fragmentation in here. I give you one example on this. Thank you to listening for about my personal situation once more. I again need to share some reasons of midlife crisis and depression now. I have 2 children, great children, one of them being 17, the other one being 15. I love them. The typical Sunday morning breakfast looks like this. They show up with their phone, right? They show it to me, and they have 17 different new apps on it, and I try to understand what these apps are doing. And then the data protection Ayatollah in me starts declaring, listen, you should not do this because blah, 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 blah. And then both of them pretend listening to me and leave, right? So that's the situation, right? So, and that's not new. It's like this now for the last 5 years. And that gives me, being a lawyer, triggers a question, which is, can I do something on this? And the typical answer I could give from a legal standpoint on this is, well, the situation in Europe looks like this, right? This is a very simple question. It's the question, when do children have to ask their parents whether they are entitled to allow another entity to process their data? And the answer given by GDPR is, as always, it depends. It's not easy, right? It's somewhere in between 30, at least a maximum is 16, a minimum is 13, and in between it can be whatever. And this is the European approach on this. So it's everything between 13 and 16 is possible in Europe. So I should move with my children strategically between different countries every year, right, to optimize the outcome of this. And of course, it's not only the minimum age of agreement, it's every more fundamental issue within GDPR, where the framework looks like this, because that's the second main hypothesis of this presentation, because there are underlying conflicts of values which are neither debated nor solved, right? It's a question of what really do you want to protect here. So one of the conflict of interests or values that constantly appear here is a conflict between public interests and private interests, control of data versus sharing of data, openness versus autonomy. And in every single data-driven economy and in every single data-driven legal question, this conflict of interests need to be outbalanced, and as long as we don't have an agreement within the society how to solve this, it will not be solved by the lawyers. It will in particular not be solved in research projects like the ones that I mentioned before, leading to a situation which very much looks like this. This is a slide that I show in every presentation I give, right? So it's no matter what I talk about, this is something I always show. because it's always true, right? So this is, after 30 years of internet regulation, from an academic point of view, this is the situation. It's always late, it's always fragmented, and it's always irrelevant, therefore. However, the only one winning in this game is me, right? Because it produces so much uncertainty and so much complexity that although you start blaming me in year 3 or 4, you still need me in year 1, right? So the only one winning in this situation is the lawyer, which is good for the lawyers, but probably not for the economy in this country. Okay, I skip this for time reasons. I skip this for time reasons, and I just show you 1 or 2 examples where this conflict of interests appears. There is a golden rule in European data protection coming from this time where I showed you the image from 1968 or 1970, right? This is the starting point of European data protection. And the golden rule goes like this. If you want to understand European data protection law, that's easy. It goes in 10 seconds, right? European data protection law in 10 seconds is the following. The processing of personal information is illegal. Please repeat. The processing of personal information is illegal. That's the rule, right? That's the rule. And there are just 2 exceptions of this rule. One is you have informed consent. This is why we are so crazy about all these sheets and all these cookies and blah, blah. That's one thing. And the second one is you have a legal basis. Right? There needs to be a law somewhere saying you are allowed to process this. That's all. The problem now is the legal basis that you could have, could inter alia say, listen, you are allowed to process this data if you have a legitimate interest to process it, right? So there's a huge loophole here saying, although it's illegal, although our rule is don't do it, we have a huge loophole, which is if you can argue that you have a legitimate interest, then feel free to do this. And the problem, of course, is now what is a legitimate interest in this area? Let's put again as an example here the question in how far medical data that was collected for treatment should be available for research. The answer given on this in the GDPR is, well, we don't give you an answer on this, because the first thing we do is it might be legal, provided that there is a law allowing this, because no longer there is this so-called purpose limitation in place when it comes to processing of information for research purposes. So that's the outcome of this. The outcome of this is that every single member state in Europe at the moment is invited to decide whether or not research is a legitimate interest that should be allowed by law to process data that is collected for treatment purposes for research. And the answer of this obviously is quite the same like in the question how old the children have to be. It's given in every country differently, and it's given in every ethics committee in every hospital differently, which leads to a situation which has made the simple question, what about secondary use of medical data for research purposes, even more impossible to be answered in 10 minutes than before. Again, it's only the lawyer winning, right? Because you need a lot of lawyers to get through the struggle. It's not necessarily the research. 28 possible derogations. And of course, there's not just one continent, one law, therefore, but it's 28. And that's a funny figure. 331 is the amount of pages, that's the amount of pages the Austrian legislator needed to transpose GDPR, which is in theory directly applicable. 331 pages in the official journal of the Austrian legislator. And Austria is, of course, just one. So multiply this with 26. And then you have countries like Germany or Austria having a federal structure. So in theory, let's multiply this by 10. So like in Austria, 10 different data protection laws. So this is something, the amount of pages that you probably would need to read if you want to have an answer to the question, what exactly is legal now in Europe coming from GDPR, which was, as I said, coming with the promise, one continent, one law, right? So this is the complexity we are talking about. And that has consequences. One of the consequences of this is Datenschutzgrundverordnung is the so-called Unwort des Jahres, which is the least popular new word in the German language. There's an election every year taking place. What is the most terrible word that was invented? And Datenschutzgrundverordnung, so GDPR in German, was elected last year as the most terrible new word, right? So that's the outcome. And the Commission sees the problem and reacts very, very funnily, in my view, because what the Commission then did, when the Commission realized, listen, we have a problem here, people do not really understand that this is a useful piece of legislation, they came out with a paper like this one. This is the official, one of the official announcements, so it's from the website of the Commission, one of the official announcements how the Commission tries to explain to Europeans why GDPR was a success. And I ask you the rhetoric question what you would do in this situation, right? So you have the task to sell this piece of legislation, although people think that it's the Unwort des Jahres, yeah? Okay, so what would you do? So this guy or this lady who did this was very innovative because one of the things he or she did was that she did this graph here. And this graph here shows the amount of Google searches, okay, the amount of Google searches undertaken in a given time period. And, you know, GDPR is in blue, and Beyoncé and Kim Kardashian are in orange and white, right? Just again, for the older ones, this is, I needed to Google this, right? So this is Kim Kardashian, right? So the success story is, during the peak month of May 2018, GDPR was searched more often on Google than even American superstars, Beyoncé and Kim Kardashian. Isn't that great, right? So isn't this a true success, right? Okay, so this is where we stand. Second example, again, a screenshot. This is of course Streisand, Barbara Streisand, being very, very well known inter alia for the so-called Streisand effect. All of you know what this is, so I don't need to go into any detail here. The Streisand effect has something to do with GDPR because one of the inventions of the so-called invention of GDPR was the so-called right to be forgotten, right? So everybody has a right to be forgotten. The right to be forgotten was invented, in a sense, by a person who will be rightly memorized in the 22nd century for having successfully claimed for his right to be forgotten. That's Mr. Mario Costeja Gonzalez, a Spanish law professor who had fought for this right to be forgotten in front of the Court of Justice of the European Union, finally successfully fought for this, which has the outcome that if I Google for his name, this is what I see. So kindly, I'm already provided. When I insert here Mario Cos, this is what I get as a proposal. So this is how well he was forgotten, Mr. Gonzalez. So he very successfully claimed for this, and this right then made its way into Article 17. Okay, Article 17 GDPR is now the so-called right to be forgotten. One of the many things I want to do when I'm retired is I want to write a book about quotation marks in laws. Because one of the strange things here and in other laws is that the right to be forgotten is under quotation marks. This is the official journal, right? And I constantly ask myself, why? Is this because is this a sign of irony? Is it the legislator not really, or is it a quote, or what, why, right? So it's under quotation marks. So this is under quotation marks, the right to be forgotten under Article 17 of GDPR as it looks at the moment. And everything which is in red is food for income for lawyers because it depends in different words, right? So there is no such right to be forgotten in principle, and things get even more complicated if we are again in the urgent need to outbalance conflicting fundamental values right there. For example, there is no right to be forgotten if you still need this information for exercising the right of freedom of expression and information, which is the very sense of everything that is done on the internet, right? So in the very moment something is shared on the internet, there is no longer a blunt answer to be given, which is there is a right to be forgotten. One last example. I know that I'm already nearly over my time. One last example I want to make here is the most recent copyright directive. So as in data protection, we also have a huge amount of new laws now coming from this perspective. And there is this famous Article 13. By the way, this is something you should really talk about if you are European and you have children in this age, like I do. Speak about copyright directive with them during Sunday breakfast. You will be very, very impressed about how much they know about it, because all of them watch YouTube and there's so much on it on YouTube, and it's really a disaster that we lose this whole generation here, because many of us us being the elderly, don't see what they are reading and listening and seeing on this. So they have a very, very strict opinion on this. And this is the outcome. The outcome of this first is YouTube or something is now the one to be held liable, right? So there is no longer a network thing there. It's just one entity to be held liable. And this one then needs to authenticate the legibility of the upload. That's the easy thing, right? So it's very easy to write into a law, YouTube, you are liable, and YouTube, you need to check what's going on, right? This is it in a very, very short answer. The problem now, it's a Lex YouTube in my view. Everything there is on YouTube. The problem now is how to do this. How to do this? Let me just show you this. This is what happened on the internet in 2018. 4.3 million videos viewed every second on YouTube. So the problem is now how to do this. How do you do this as YouTube or Google, right, to meet this requirement? So one of the things the lawyers then answer is, that's the problem of the company, and the company will ask the IT experts, and the IT experts will then come up with an algorithm, right? So that's the buzzword at the moment from the legal perspective. Let's ask the technical guys making an algorithm. The problem with the algorithm is that the algorithm at the moment looks like this. Last example, Facebook and this terrible shooting that took place in New Zealand 2 weeks ago or so. So what exactly happened there? I take this as an example because I think it's quite obvious that probably nobody in the world wants to have this online, right? So there's it's different in copyright. This is very easy. That's a very easy example. And it's also very easy because it's quite obvious that this is illegal. Very different from copyright problems. It's obvious that it's illegal to see or to watch or to upload how people are shot, right? So that's a very, very, legally speaking, it's a very, very simple case.
Illegal or undesirable?
So illegal. It's certain. I don't think that there's any jurisdiction where this would be legal, right? To show this and to distribute this. But that's another question. So I think legally speaking, it's a very simple case. Very simple case. So and therefore it's in my view interesting to see what happened in this case. So what happened in this case was that this was, according to Facebook, I mean this is what Facebook says. I don't know whether it's appropriate, but I assume that it's appropriate. So what Facebook says is that that video was screened live and that about 200 people saw it live, right? And then 8 minutes after, or 12 minutes after the live broadcast ended, that was reported to Facebook, right? So 12 minutes. The problem is that in between these 12 minutes, somebody had uploaded this on another social network, 8chan in this case, in 12 minutes, right? And from there, it was then shared several thousand times within several hours only. And then in 24 hours, it was uploaded 1.5 million times. 1.5 million times. There was an attempt to upload it, and that was unsuccessful only in 1.2 million cases. So there's a difference between those two figures, which is 300,000, right? So 300,000 uploads that were not seen by Facebook to be this scene, right? Which is a simple scene from a technological point of view and also from a legal point of view. And that in 24 hours, okay? So this is where we stand if we are willing to assume that Facebook is from a technological point of view able to do this better than many others. This is where we stand from a technological standpoint at the moment. And that leads to all kinds of censorship issues because the algorithm obviously is not working in this field, and it produces all kinds of unwanted effects on markets that we could possibly discuss in the debate. Let me finish with one single note on this here. I very much feel myself every day in this situation here. So me being typically this person here, and that's the guys doing the technology. Okay, so thank you very much for listening, and I'm very open to your questions.
Okay, thanks for sharing your depression.
Thank you.
And let's ask for questions.
So one aspect that you did not address here, you cover so many aspects, but in the United States we have Section 230 of the 1996 Telecommunication Act, which is not about copyright. It's about that platform publishers are not really publishers, so they don't have liability for content posted by third party. What is the European situation on this issue?
So,
without Section 230, we wouldn't have the YouTubes and the Facebook and all of these. They exist because of Section 230.
Okay, thank you for this question, because I was not clear enough on this. That is also the case in Europe, or it was also the case in Europe. So the e-commerce directive from 2001 is quite similar to the American situation here, but that is at the moment changed when it comes to copyright. That's the new invention of this new copyright directive.
But just about copyright.
At the moment,
what about liability?
Well, I mean, copyright comes with liability because
but you are liable for all kind of other things, like slander and libel and whatever, right?
Let me be a little bit, let me extend this. So at the moment, we have it only on copyright, and the e-commerce directive is still in force. The next step is already taken at the moment politically, which is if we already have these filters in place for copyright, then let's use it also for serious criminal offenses. And then the next step is not too far away, which is then let's put all this away because we only have 5 or 8 players and we want to regulate them more intensely, and let's do this. This is already on the political agenda every day, I would say. It's not in the law yet. In the law, it's only on copyright at the moment. But that's, in my view, one of the most important changes of this new directive. And this is, in my view, one of the reasons why so many people are rightly upset about what's going on there.
Thank you.
You remember yesterday the discussion on the AI and accountability, liability. Is there some? So who is responsible if some application is doing harm? Is there something underway in this European context, or still fragmented? Or?
So thank you for the question. Again, allowing me to share my frustration. If you share for AI and liability in a typical legal database, the outcome is about 30,000 hits. So there's 30,000 articles that are produced on this at the moment. So it's one of the real buzzwords at the moment in my field, right? And there are all kinds of, ethics committees, consultancy bodies, whatever you have in every single member state thinking about this. Nothing which made its way really into the law, because again, it's very unclear who should really pay the bill. Right? Whomever you ask, they have an opinion about who should pay the bill, but there's no agreement on this, and there's no real academic debate about this. And as this is, again, not really undertaken, the outcome will be, as always in my field, random, or outcome of a lobby, of the strongest lobby group. So people who might be, it could be, if you're talking about autonomous driving, those who could pay could be the driver, it could be the owner of the car, it could be the manufacturer of the car, it could be an insurance, and it should be the victim. It could be the victim, right? So that's the 5 options that we have, and you will find somebody arguing for any of the 5.
Could I extend just a small, because you remember the presentation of Jim yesterday comparing the European, American and Asian situation. What is your opinion on that? Because there is also this liability and regulation, especially on this AI.
Yeah, in Europe we are very good in regulating and we are very bad in inventing. And that's my view, right? That's it, right? And we are very good in trying to regulate solutions that are not on the market yet, 5 years ahead. I mean, I heard today in the news, I heard that Korea started today 5G everywhere, right? And in Europe, we don't have 5G, but we have laws covering it, right? So that's the difference.
How would you write a model law for the European internet regulation? Would you write it down and would you publish it in an academic journal?
No, I would. So that is very easy. I would not publish it in an academic journal because the wonderful thing about our job is we can do whatever we want, and because nobody cares, right? So this is why I mean, our freedom comes with a price, and the price is total political irrelevance, right? I mean, therefore I would not put it into an academic journal. I would possibly go into any of these ethics committees, blah, blah, which I have done in my life, and that's also quite frustrating because you all see quite quickly that this is not really relevant either, right? But if I, however, could write something like this, it would be the outcome of a long-lasting academic debate about the fundamental values below the law, and then it would be very short and very abstract, and putting everything else into the hands of judges.
I have a question. You know, many of these regulations come from, let's say, there are ethical principles like, privacy, and then you try to come up with some kind of formulation about those principles that protect citizens. So what I'm asking here is, where is, in what you said, what is wrong? It is wrong in the implementation of those? Or should we just accept that those principles have to be revised because technology makes it impossible to satisfy those principles? I'm trying to understand, where are the problems? Are they in the implementation side, in translating those principles?
So I think. I don't think that it's in the implementation per se is a problem. There are two problems in my view. The first one is none of those principles is absolute. So each of these principles is in conflict with other principles. There are very few of those principles which are absolute. Human dignity might be one, right? Human dignity, at least in the European understanding, is absolute, right? That is, by the way, one of the reasons why data protection is so prominently protected here, because human dignity was one of the main arguments of the development of the whole concept. But apart from this, all the others, privacy, freedom of information, freedom of whatever, copyright, property, whatever you take, none of those is absolute. They are always potentially in conflict, and you need to outbalance this. The problem with this is you need to have the debate on how to outbalance this. And as long as we don't have this debate in a proper format, and as long as we don't have some kind of agreement on this, or at least a majority clearly having a standpoint on this, the outcome of this will be very, very detailed random rules with all kinds of side effects that politicians don't understand. That's the first thing. The second thing is if you've only got a hammer, everything looks like a nail. So what politicians do and what lawyers do is that they regulate things with political instruments, legal instruments, traditionally known from a technological environment that no longer exists. So what we therefore also need is much more of technological understanding in the regulatory field. Third, in every single of those papers, you can read that it pretends to be technology neutral, which is of course not the case. Nothing of this is in a technological sense neutral. All of those have specific technologies in mind and try to regulate specific technologies. The problem with this is if you regulate something like in the GDPR with the understanding of the world of 2012, which is the case, or even 1968 in many ways, it's probably not really working any longer. So the innovation periods that we need for changing the law are by far too long. That needs to be shorter. Or, that would be the other option, be much more abstract. So coming really back to very fundamental principles instead of, you know, regulating cookies as a specific problem. Who really cares about cookies in 10 years, right? Who knows what will be about cookies in 10 years?
Thank you. I think it's quite clear that GDPR is not an ideal situation. It's broken in many places and has unintended consequences. I just wanted to hear your opinion on whether there's anything good about it as well, in ways that, even if it's just the intention, because one of the things that GDPR certainly did is that it made us talk about privacy.
Yeah.
Right, and it needed that bang for us Europeans to kind of actually talk about what we expect from privacy in the digital age. You know, so where do we start? I mean, it's always going to be a broken system. It's always going to be in need of patching up. Yeah. But what's the alternative? The alternative is the Wild West West, and
because shifted, for two reasons. Three reasons. First, there is a fundamental principle in GDPR saying, if you agree that your data is processed, the processing is legal. This is the best instrument for companies having contractual relationships with many customers. So per se, this is the best instrument for Google, Facebook, Uber, Amazon, take whomever you want, to make their data processing perfectly legal, different from new market entries not having this contractual relationship with their customers. So this helps American companies tremendously from the very substantial reasoning behind it, from day one onwards. And it didn't take them long to understand this. And Google and Facebook and others are therefore those taking profit out of GDPR in their business models, also in Europe, in comparison with European competitors. The second reason why this is the case is that, different from what I heard here in different scenarios, it's not true that they ignore the law. By contrary, they constantly monitor very well, and they have a lot of people being very bright, working in their legal departments, trying to find what the law really says, also very different from small companies. I mean, one of the outcomes of GDPR is that every stupid non-profit organization in every member state now is upset that their membership list might be illegal, whereas the potential of really dealing with these issues strategically and professionally is tremendous in these companies. I mean, for example, if you take the Austrian Data Protection Authority, how many people work there? Make a guess. So it's about 30. How many of them are academics? About 1/2. So about 15 academics. How many of them have a technical background? Zero, right? There's not a single technical expert in the Austrian Data Protection Authority. So this is the enemy for these companies, right? I mean, okay, so two. So third, it's true that we speak a lot more about privacy, right? So there is some more privacy awareness now in Europe. I agree with this. But the day-to-day outcome of this is, on the one hand, all of us playing Minesweeper to try to, click on the right point on the screen to make these cookie messages go away. And at the same time, in every single European member state, new surveillance laws making their way into our daily life every day without anybody caring about this, right? I mean, I don't know. I didn't see too many people really arguing in Austria about the changes in the criminal procedure code taking place here last year. Although, of course, there's a lot of privacy infringing instruments in there. There are some. I did too. Yeah. Okay. So there are some, but. Yeah. Okay, there are some, including me. Anyway, so it's not really, it's not true. Just, knowing about privacy as a value does not necessarily change day-to-day politics. So that on this. But finally, to be a little bit friendly at the end, of course, it's nice. Again, the lawyer like me wins, right? Because when I started with privacy law 25 years ago, I was very close to, people doing legal anthropology or something like this, right? Or I don't know, ancient legal history. And now it's in the center in the core of the whole system. So that is nice. Yeah? That is the nice part of it.
Sorry. Try to be
I have a question for clarification. I very much agree with your assessment from my sort of lay point of view, but I thought that when it comes to programmatic advertising and to not accepting certain form of automatic consent, that GDPR was actually making a difference,
Well,
in all countries.
Okay, so that is a very difficult question. My answer to this is, in theory, there is something in GDPR on this, but again, there is a huge discrepancy between a recital and the article. And smart lawyers at Google and Facebook, etc., use the wording of the article. It's Article 7.4 if you want to check it. And that makes a huge difference. And it's still not clear how the Court of Justice will decide on this. We do have a case on this. This is the French Data Protection Authority fined Google with a 50 million euro fine for this very reason. But that is contested. And there are people arguing that Google has a correct position on this. Let's see.
Okay, a bit relating back to the last thing with the mafia story. I think that one can also see the mafia as something that comes up out of a space where there is no regulation or no law, because they then regulate the story for you, and maybe it's then the platform. So I wanted to ask you, what would be the best thing to put you out of the job for the next 20 years? Because you said in the beginning you're going to be busy, and I don't know if what you proposed before, like doing principles, and then pushing it more towards court, is actually bad for the lawyers. It's still a good solution for lawyers, I suppose, because then there will be lots of legal battles. I don't know.
Yeah, I don't know either, right? So I don't know. There will probably be a lot of legal battles, and I'm therefore quite confident that lawyers will have a lot of work to do on this for the next. There's a very, very nice quotation from Gordon Brown, the former UK Prime Minister, who once said, when it comes to the rule of law, the first 5 centuries are the most difficult ones, right? And this is obviously true also in this new area, so I do not really worry about us. But the positive side effect of my approach compared to the one that we have at the moment would be at least the unintended consequences of such a huge piece of legislation would be smaller, because it would be significantly shorter, right? But that is the only benefit I see. I agree. At the same time, just one more remark, at the same time, many of my young students are very much concerned about whether they won't be the horses of the 21st century, because they also will be replaced by machines. Right?
All right. Thanks for the presentation. And